That goes back to the idea that your home is literally your castle, that it's a place where you're supposed to feel the safest and most protected.
Since late 2011, that's been law in Wisconsin, meaning that if somebody uses violence to protect their own home, they have a strong case that they are acting in self-defense. This is different than if you get into a scuffle on the street.
When you have a fight on the street or something like that, they're going to look at what opportunities everybody had to escape or otherwise leave the situation.
So if you're inside your home, you don't have that duty to leave the situation, but you do have to act proportionately.
If there were 3 shots to the back of the head, for example, even though it occurred in someone's home, I think any prosecutor would look at that and say, well, I'm not so sure these are defensive wounds here.
So how do these claims play out in court? A defendant has to first introduce some evidence of self-defense, but then the prosecution has to prove that self-defense does not apply. But the claim can also prevent a court case altogether.
Every attorney is going to have different advice, but my personal tactic would be if I know my client was acting in self-defense, if I find them to be credible about that, I would rather have them cooperate with police and give a complete statement on the front end before charges are issued.
So you don't yet know whether the doctrine will apply here, though the police chief says that it might apply. It's largely a decision that the DA will get to make.